Good evening. This is the Malden Board of Appeal hearing for April 17th, 2019. The meeting is televised, and if there's anyone else here that's recording, if they could just let us know. I do not see anyone. Could we look at the minutes from last month, which was March 20th? I know you all got them from Kathy. Any corrections, comments, and if none, if we could get a motion to approve these. This is the minutes from last month, March 20th. Okay, second? All those in favor? Aye, okay. So we have two items this evening, and I'm going to start with Olive Ave, which there was a request made from the city planner, who's a member of the planning board, if she could come before us, and I think she'll explain the situation. She's looking for some clarification. We held a hearing, I believe, in June of 2020, and her interest relates to the hearing that evening. So, Michelle?
Thank you. Michelle Romero, City Planner. I am here. I want to thank you first for the opportunity to address you. I'm requesting clarification and intent of your decision rendered on June 20th, 2018, regarding the request for a variance of the frontage requirements as per plans at the property known as and numbered 57 Olive Avenue along Monmouth Street, and also known by City Assessor's Parcel ID 148627711. When the petitioner filed the request for a variance with the city, there was a specific plan filed with the application electronically that was filed in my office with the city's Permits, Inspections, and Planning Department. That is the plan of record on file in our department. This is the same plan that is referenced in your notice of public hearing for the June 20th, 2018 hearing, to which you directed abutters and members of the public to that same application and plan. This is the same plan that petitioner physically presented to you at the public hearing, following which you rendered your decision to grant the variance of frontage requirements. This plan is entitled Plot Plan of Land of 57 Olive Avenue in Malden, Mass. It's dated April 12th, 2018. It's prepared by Paul J. Finocchio of PJF and Associates, Wakefield, Mass. He is a professional land surveyor. It is also prepared by John D. Sullivan. He is a professional engineer. The plan also has the notation above the title LCC 8066A and 759B. That plan, which I believe you have a copy of, it's in your records, depicts petitioner's proposed new lot. It's labeled Lot 2. It contains 18,325 square feet and approximately 184.31 feet of proposed frontage along Monmouth Street. I am respectfully requesting this board to provide clarification as to whether this plan was the subject of your decision to grant a variance of frontage requirements. In other words, was the variance granted based on this plan? I'm requesting this clarification so that I may inform and advise the planning board with respect to its review and action on petitioner's request for subdivision of the property. The building commissioner will also rely on this plan with respect to issuing permits for the property. Thank you, and I'm available to answer any questions about this request for clarification.
Okay, so our hearing was back June 20th of 2018. The two young ladies over here were not on the board at the time. These gentlemen were, along with myself. So would you like a verbal clarification as to an acknowledgement that this plan that you just referenced, that I will also mention is referenced in our minutes, you want us to verify that that's the plan that was relied on when we granted the variance, correct?
Yes,
Yep.
that would be
Okay.
great, thank you.
So
Any
I'll ask
clarification?
each of the members, as far as myself, I'm confident that this is the plan that was the basis of the variance being granted that evening. And again, I know it's referenced in in the minutes. So I'd ask Mr. Sullivan, do you recall, are you comfortable? Yes, I agree. This is the plan. Okay, and Mr. Sherwin? I agree as well. Okay, so the three of us are confident that this is the plan that was relied on. Is there anything else we could provide you with?
No, that's it,
Okay.
thank you very much. I will report back to the planning board and the building commissioner.
Okay.
Thank you.
And the planning board now is for subdivision?
The planning board will be reviewing petitioner's request for subdivision of the property.
And
we want to make sure it's the correct plan.
that's happening now, 9 months after our hearing? I'm just curious, the lag of time, why it's...
That particular variance
Was granted in
decision was granted in June
June
of
18.
2018. It's my understanding that that decision was appealed by several, or at
Oh,
least
okay, right.
several abutters. So
Okay.
I believe the litigation has ended, so they are
Now
moving
they're
forward at
going
this time.
forward, the petitioner is going forward with hoping to do the subdivision.
That's my understanding of it.
Okay.
Yes, that's why I want to just make sure we're all on the same page.
Yep, yep. I'm
Thank you.
confident this is it.
Great, thank you very much.
Thank you.
for your time.
Okay. All right, let me clean up here for a moment. All right, our second hearing is for the property at 125 Highland Ave, and this is a continuation from a hearing last month. My memory is that when we tabled, I felt there was a sense from two members, Mr. King and Mr. Sherwin, about the inside of the property and what existed back there in 2001 or whenever it was that would have been the justification for why the former board member called for the installation of the systems there. And so as a result of that, two of us did go out to the property a week later, Mr. Sullivan and myself, and I'll let Mr. Sullivan speak, but from what I saw, it was a two-family house, basement, not a unit, might have been a finished room there. First floor, a unit, and then second and third floor constituted a unit. So it's two living units. The property appeared to be in very good condition with hardwired smoke and carbon monoxide detectors. No sprinkler system was installed, and the only other thing I would add is we can't go back in time, but I have had some conversations with some folks that have been around the city for a while, and there was some sense that many years ago, this particular property maybe had been neglected and whatnot, and it does show on the record that the former owner, who was the petitioner at the time, actually lost the property in foreclosure. And not that that's always the case, but when properties get foreclosed, sometimes there is, the condition of the property can suffer. So I don't know if that was part of the reasoning that our former board member called for a sprinkler system being installed. So I just wanted to make those comments, and I know also that, Adam, I felt you had thrown out a suggestion to Mr. McDonald to address a certain issue. I forget exactly what that was, if you wanted to weigh in on that. Do you remember?
It was more along the lines of whether we could amend a prior variance, and I'm of the opinion that we can.
Okay. So you don't need any more clarification on that?
Unless council has anything to add to that.
All right. Go ahead, Ms.
Well,
McDonald.
I had prepared a brief memorandum at the request of Member Sherwin, Mr. Chairman, and I do have it for the board. But my arguments regarding the ability to amend and the appropriateness of amendment under these particular circumstances are essentially the same as I argued at the original hearing a month ago, except I would say that I think my arguments have been buttressed by the fact that during this interim period, we were able to obtain from the city's file copies of what I think are very relevant documents to the issue. And if I may approach anyway, I can. Those are attached to my brief memorandum. I made
Okay.
an original and 5 copies or 4 copies of the memo with those materials attached to it. And the petitioners, during the interim as well, were able to obtain 12 letters of support from various property owners in the immediate vicinity. So I may send
Okay.
those to the board as well.
Sure.
But as I was saying, that we were able to obtain from the city's file related to the subject property, that in fact, in the relevant time frame and after the issuance of the variance that's the subject of this proceeding, the then owner did make application for a building permit. The then owner did apparently successfully complete the renovation project. He then sought, with an application for a certificate of occupancy, a formal recognition of the two-family status of the property from the city, and was in fact granted a certificate of occupancy by the then building inspector, Paul Johnson, designating the property as a two-family. So I was unaware of that during our last meeting, didn't have the benefit of those materials, but I would respectfully suggest that, again, those just further buttress my previous argument that essentially this ought to be treated as a grandfather two-family, notwithstanding the admitted failure to comply with those 2 particular conditions of the original variance, pursuant to both now Chapter 48, Section 7, which limits the ability of a municipality to bring an action of enforcement, civil or criminal, for alleged violations related to zoning or the failure to comply with conditions of a special permit or a variance for both for in one instance a 6-year period and another a 10. But in either instance, we're well past that at this point. We're 16 or 18 years post approval. And it also suggests that now Chapter 48, Section 6 could apply as the more generally recognized grandfathering statute, in that this property has been used as a two-family pursuant to a validly issued certificate of occupancy as a two-family, well before the point at which zoning in this particular area of the city changed from Residence A, which permitted two families, which now Residence A does not permit two families in that district. So it means even more support, I would suggest, for the position of the petitioners that these conditions can and should be stricken from that variance, i.e. the variance can be amended at this point, striking those conditions to remove any potential cloud or question about the legal status of the property as the two-family now.
I did, Adam, happened to just come across some older files and did come across a case that was held here in the city, interestingly, that also involved sprinkler systems. But the point I'm bringing up is that there was an amendment done. It turned out that the buildings fell under the threshold. It's a commercial self-storage facilities, and 7,500 square feet is the threshold. And it was determined when this company built some additional buildings on Route 1, the newer buildings turned out to be less than 7,500 square feet. So the petitioner came back and didn't want to sprinkle, they didn't want to spend the money, I guess. And sure enough, the board, this goes back to 2003, the board, this board amended the decision from what originally had been put down as a requirement. Anyone have any questions for Mr. McDowell? No? Okay. I don't believe we have any public participation. These folks are with you, correct?
Yes, these are the petitioners,
Okay.
Mr. Chairman.
But I will make note of the fact that some individuals have submitted letters. We did not have any input at the prior hearing, either supportive or in opposition, but I'm assuming these are all in support of.
Yeah, that's correct, Mr.
okay.
Chairman.
And what number are we, 125? So this is across the street at 126 Highland Ave. Monica Au, she's writing this correspondence to support the petition for the above referenced individuals currently pending before the Board of Appeals relative to the clarification and legalization of 125 Highland Ave as a two-family dwelling. And at 109 Highland Ave, Jeffrey Ling, accept this correspondence as support for the current pending Board of Appeal issue and clarification of 125 Highland Ave being recognized as a two-family dwelling.
If I could interject, Mr.
Sure.
Chairman, it was kind of a standard form, so.
I saw that after my second one, and I was going to, but I am going to mention the folks that signed off in their addresses. Stephanie Secu at 137 Highland Ave. PJP at 132 Rare Highland Ave. William Spatafora at 136 Highland Ave. Donna Spatafora at 136 Highland Ave. Jake Jordan at 136 Rare Highland Ave. Carmen Shea at 74 Oakland Street, which intersects with our subject property. Brian Sylvester at 75 Walden Street. Jose Carlos de Silva at 311 Pearl Street. And Hugh Hawley at 28 Avon Street. Finally, I cannot read the last person, but the address is 182, I think Mills Street. Is that right? Yeah, that's a few blocks away. So those folks, a dozen or so, are all writing in support. So thank you for that. Any other questions? No? Okay, comments. Would anyone like to make a motion?
I motion to amend the June 6, 2002 variance and amend it to eliminate the fire sprinkler
I don't know
requirements.
if that's the right date, though, Adam.
That's what
You're talking about
The prior variance.
the prior one. I think it was in like November or December of '01.
It was granted at the meeting of December 20th, 2001.
Yeah, that's what I thought. They had a November meeting,
Oh,
but
I see.
it was delayed for no show, and then it was heard the following month, and that's when it was granted with the two conditions.
So I'm sorry, what's the date of that again?
December 20th, 2001?
December 20th, 2001.
So I motion to amend the December 20th, 2001 variance to eliminate the two conditions related to the fire sprinkler.
Okay, second. And all those in favor? Aye? Okay, so I believe we have a vote of 5-0 in favor.
Thank you all very much.
Okay.
Have a
thank
good
you.
evening.
All right.
Yeah. I'll send I'll send out a draft so you guys see if it makes sense. Yeah, no, I don't agree with that. I think that we have to amend the variance. I think we're still on, but we're okay,